This is Sarah Badzagalupi, and I'm an attorney here at Chapman Law Group. I work for the Licensing and Regulatory Division, and I want to talk to you about the orders compelling examination today, which is something that you might be unfortunate to encounter if you're being investigated by the Department of Health for impairment reasons. The issue that is specific to today is what involves impairment. So impairment is a word that you probably heard of before. Impairment is when a practitioner is unable to practice with reasonable skill and safety due to a mental health issue, a physical disability, or even substance abuse. In fact, I would argue that in most cases, impairment tends to involve substance abuse issues, whether for drugs or alcohol. You may have actually heard of the impaired practitioner programs in the state of Florida. You may have even seen one of our videos about it before. I'm talking about IPN for nurses and PRN for everybody else. These are the impaired practitioner programs in the state of Florida that usually come into play if you, as an individual, have been accused of impairment. But what happens if you don't want to participate in an impaired practitioner program? Whether you were referred to the program by your employer for a variety of reasons, whether it was testing positive for a drug test, whether it was because you appeared impaired at work, doesn't matter how real the accusations are. They could be total bogus, but the people that you're going to hear from first are usually these impaired practitioner programs. Not everybody belongs in IPN and PRN. In fact, I would argue that if you do not have an impairment issue, you probably don't want to partake. If you don't participate with IPN or PRN, then really what's going to happen is that these entities are going to refer your case back to the Florida Department of Health, who is then going to initiate an investigation against your license on the basis that maybe you're impaired. The circumstances of your case might affect the underlying, investigation that the department's going to look into. So if the reason why they're suspecting impairment is because you tested positive for THC in a urine screening, doesn't matter if it was pre-employment or reasonable suspicion, or whether you were involved in an audit and maybe you're suspected of drug diversion. Even if you got a DUI and now the department is investigating you for that DUI, that's what the department's gonna do. The basis of all this is that the accusations, the facts of your case, are enough to suggest to the Department of Health that you may be impaired and may be a danger to Florida citizens. The department was created, after all, to protect the public. So that's what their interest is going to be. In fact, that's the interest of IPN and PRN. You have a letter of investigation. That's the first thing that you're going to get from the Department of Health, and it's going to tell you, hey, we're investigating you because we think you're impaired. You're probably going to get a lot of documentation that is actually going to specify what the underlying facts are or the underlying accusations. And you may be relieved when you look up your license and see that it's still clear and active. Well, this is because an investigation by the Department of Health is not a formal charge. That is simply the department notifying you that now they're going to investigate the case to determine if in fact they need to formally charge you, or in other words, if they need to give you an administrative complaint. That is the formal charge that would show up on your license. But while you're under investigation, this doesn't happen. The investigation is just a notice to you that in the background, the department's going to test and see whether they can collect enough evidence to prove that you should go to an impaired practitioner program, or that, in other words, your license should be disciplined. I get a lot of clients that call me, usually too late. That's because they're drawn into a false sense of security when they get this letter from the Department of Health that says they're being investigated, but their license is clear and active. So you're under the impression, which would be correct, that you can continue to practice. This is true, but it doesn't go on end. At some point, if you have not prepared an actual defense, have presented evidence to the Department of Health that you are actually not impaired, there's really nothing there to discourage the probable cause panel, who's going to judge your case, from actually formally charging you. And then you end up with a complaint that is hard to get rid of. The only way you can get rid of that complaint, in fact, is by going to a formal hearing and going to trial, which is so much more expensive than it would have been if you instead had tried to get the case dismissed by hiring an attorney before the investigation was over. But let's talk about something that is a little bit more insidious, something that we don't see happen all that often, but something that could very well happen. In fact, I've seen a surge of these recently, and these are orders compelling examination. These happen throughout the investigation stage of the case. They don't generally happen after. So what is an order compelling examination? That is basically the Department of Health saying that they have the power to make you go to an evaluator who is going to assess your ability to practice with reasonable skill and safety. That's what that is. And you can't avoid it. It's an order. Now, this is not public record. It'll just be sent to you. But it's something that if you get in the mail, it's incredibly serious. The order compelling examination will actually outline the facts that the Department of Health has to support their request, or their mandate rather, that you need to actually be evaluated. And they will give you the address and name and phone number of a doctor, an evaluator that you need to go to complete this evaluation. Who is an evaluator? Well, evaluators are the same as the evaluators that are used by IPN and PRN. However, in this case, it's the department sending you there, and you don't have a choice. So you might think, well, maybe I could have gone directly to IPN and dealt with this. Well, I beg to differ. When you get an order compelling examination, because it's an order, you don't actually have to pay for the cost of the evaluation. The evaluation is going to be the same, but now there's an actual case number because you're being investigated, and the department's asking you to go. So you have a better leg to stand on because you have a venue to argue if the evaluation turns out to be unfair. So I ask you to consider that. But I also want to talk about what is going to happen if you are evaluated. A lot of my clients get really worried when they get these, and I don't blame them. An evaluation is no walk in the park. This evaluator is a doctor. They are board certified, usually in addiction medicine and psychiatry, and their goal is to help the department prove their case. That's why they're there. They're trying to establish whether you're currently safe to practice, and they're trying to establish whether, maybe you are safe to practice, but you still need to be monitored by IPN or PRN. And that is something that people try to avoid in the first place. Hiring an attorney at this point is very beneficial. That's because we can help you prepare for these evaluations. We can actually help a defense from the beginning to maybe minimize the odds of you getting said evaluation, being sent to one. We can prepare a defense in the event that the evaluation is bogus. That's what a good attorney does. We have experts that we use, we have evaluators that we use, toxicologists, whatever the need may be for the individual case. But that's what you get when you hire a law firm that specializes in this type of thing. Evaluations can last a long time. They will investigate everything from your entire medical history to specifically your relationship with alcohol and substances. If you have a mental disability, whether it's PTSD or depression or bipolar disorder, the evaluator is probably going to ask you about that as well. They're going to ask you to submit to drug tests, that is blood, hair, and urine, all of them. And that will also be dispositive of what the evaluator will determine. The evaluator might decide that you're safe to go, and if there's nothing there to worry about, then generally the case is dismissed. But in my experience, that doesn't always happen. More often than not, the evaluators will recommend monitoring anyway. That's because they don't need to come up with a diagnosis. What I mean by that is that you don't need to actually be diagnosed with a mental health disorder or a substance abuse disorder in order for you to be referred to one of these impaired practitioner programs. The evaluator can simply say that the circumstances, the factual circumstances of your referral indicate that your behavior is dangerous, and it's dangerous to the public. Remember, the only thing that the department needs to prove is that there's probable cause to formally charge you, and that's a pretty low burden of proof. So if an evaluator comes back and says that, well, you probably need to go to an impaired practitioner program to be monitored, the odds of you getting an administrative complaint are astronomical. I guess crazier things have happened, but I've yet to see one who's not referred to IPN or PRN. With an evaluation, your odds of getting a settlement that does not include referral to an impaired practitioner program are Basically none. That means that you need to prepare to go to a formal hearing. That means that you need to prepare to go to trial. And that may seem overwhelming, because it is, especially if you've never been in trouble before, especially if the accusations are false, but it happens. And having an attorney step in the middle of the process, it hinders your chances. If you instead hire somebody from the beginning, then a defense plan is already in place.